Good morning to everyone. I am Dr. G. Shabir Ali, Head of the Department, LLM and Research Coordinator, VM Salon College of Law, Panji, Goa. Today I am going to present before you judicial trends in implementing Legal Service Authority Act 1987. So before going to this act, I hope that you are going through various modules on access to justice. Still you are going through other modules on access to justice. To understand the importance of this topic, that is judicial trends and in implementation of Legal Service Authority Act, you have to read modules with respect to speedy justice and amicable settlement, lok adalat, permanent lok adalat and other aspects. Then you can understand and appreciate today's topic. So before going to this, let us see what are the objectives, what you are going to achieve after going through this topic. So after going through this topic, you will appreciate the role played by judiciary in implementing legal aid and legal services in India. To critically appreciate and analyze the need, objectives and importance of Legal Service Authority Act 1987. To understand the constitution, powers and functions of Legal Service Authority Act, to critically analyze the Legal Service Authority Act 1987 as amended. So with these objectives, I am going to present before you the scheme of today's topic. First we are going to look into introduction, then referring to Legal Service Authority Act 1987, objectives and scope of the act, need and importance of the act, constitution of legal service authorities, powers and functions of legal service authority. Lastly, criteria for entitlement of legal services, means who are the people who can avail the free legal aid or free legal services under the Legal Service Authorities Act. Let us start with introduction. Judiciary plays an important role in administration of justice in settlement of dispute. Today, public in India is not happy with the role played by judiciary in administration of justice, because there is undue delay, justice is expensive and procedure followed by the ordinary courts is cumbersome. Making law is no use unless it is implemented and enforced for the benefit of public. The judiciary played an important role in implementation of Legal Service Authority Act made in the year 1987. After 8 years of delay, when the act was enforced in the year 1995, there were many uncertainties in the implementation of the provisions of this enactment, which are set aside by the judiciary through its pronouncement. In this module, the cases of the Supreme Court and various high courts in relation to legal aid and legal service have been discussed. Efforts have been made to analyze the judicial opinions with regard to the enactments and enforcement of the stated legislation. These cases have been discussed under the following heads as shown in the flow chart. Enactment of this act. In order to make this enactment, judiciary played an important role in various cases, and judiciary informed the lawmakers need to make a separate enactment where you can establish various authorities in speedy disposal of the cases. So let us verify the cases in which the court informed the lawmakers to make a separate law to deal with speedy justice. The Kerala High Court highlighted the factors which led to the enactment of this act in the case of Maryland versus Yesudas. In this case, it was held that Article 39A of the Constitution provides that the state shall secure the operation of legal system which promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable enactment or scheme or any other way to ensure that opportunity for securing justice are not denied to any citizen by reason of economic or other disabilities. The provisions of free legal aid under Article 39A of the Constitution at times become polluted by the fundamental rights to life under Article 21, and it could be treated as part of the right created under Article 21 in number of cases. So here let me give idea about Article 39 of the Constitution and Article 21. Article 39A of the Constitution comes under Part 4 of Indian Constitution, which deals with directive principles of state policy. These directives are to be implemented by the state. So duty is imposed on the state to implement Article 39A, which deals with legal aid. But these directives are not enforceable before any court of law. If the state fails to provide legal aid to any litigant, the person cannot challenge the act of the state before any court of law. The court interpreted Article 21 and incorporated right to legal aid as a right available under Part 3, that is fundamental rights. Because of this, the litigant can approach the court and challenge if the state failed to provide legal aid. So in that case, it became mandatory for the state to provide legal aid as per Article 21. Legal aid is not a charity or a chance, as is stated in the Constitutional mandate to the state and right to public. Now it is a constitutional obligation and compulsion on the part of the state to provide free legal aid to the needy society. Under this enactment, a committee for implementing legal aid schemes was appointed to monitor and implement legal aid programs on uniform basis. Lok Adalat were being constituted at various places in the country for speedy disposal of settlement of disputes between the parties with less cost. In view of the popularity of the institutions of Lok Adalat, with the passage of time, it became necessary to provide statutory backing to these institutions and awards given by these institutions. It was felt that such a statutory support would not only reduce the burden of arrears of work in regular courts, but would also take justice to the doorsteps of the poor and the needy people to make justice quicker and less expensive. This led to make the enactment, that is Legal Service Authority Act 1987. With this background, let us look into the objectives and scope of this enactment. Objectives are nothing but the ideas or the intention of the lawmakers in making this enactment. So these objectives are also highlighted by the courts in various judgments. The High Court of Andhra Pradesh, in the case of Board of Trustees of Port of Visakhapatnam versus Presiding Officer District Legal Service Authority, highlighted the objects of the Act so that provisions of the Act could be interpreted in its light. It is held that this Act was enacted in furtherance of the objectives and purpose mentioned under Article 39A of the Indian Constitution, which contemplated the state to secure operational legal system in promoting justice. On the basis of equal opportunity and in particular providing free legal aid by suitable legislation and the scheme to ensure that the opportunity for securing justice is not denied to any citizen of India. The Karnataka High Court explained the scope of the Act in A. Ahmad Pasha versus C. Gulnaz Jabin. In this case, the court held that it is twofold in its objective. The first objective covers the subject of providing free and competent legal services to the weaker sections of the society, so as to ensure that justice is not denied to them by reason of economic and any other disability. The latter portion of the object deals with general object of the Act, which states to organize Lok Adalat to secure that the operation of the legal system promotes justice on a basis of equal opportunity. It is a universally accepted fact that the courts are overburdened by judicial work and it has reached the point of alarming situation. In this situation, it will be a nerve destroying job for the presiding officers of the trial court in our country to successfully dispose of the same within reasonable time. It is in this regard, in this disturbing situation of the every mounting pendency in regular courts, that the Parliament legislated the Act to provide alternative fora in a forum like Lok Adalat, so that the arrears of work in regular courts be reduced to considerable extent and quick and inexpensive or less expensive justice made available to the needy litigants. So, with these objectives, the Legal Service Authority Act was established. In another case in which Karnataka High Court laid down the relevance of object in interpreting various provisions of the Act in Kishan Rao versus Bidar District Legal Service Authority. The Legal Services Authority Act has been enacted with the object to provide free legal aid and legal service to the weakest sections of the public. Justice is not to be denied to citizens by reason of economic or any other disability. Similar observations were made by the Madhya Pradesh High Court in the case of Punjab National Bank versus Lakshmi Chand Raj. The court rightly said that the statement, objectives and reasons make it clear that the Act was promulgated to provide free and competent legal services to the weaker sections of the society and to organize Lok Adalat to ensure that the operation of the legal system promotes equal opportunity of justice to each and every person. The Lok Adalat is efficiently performing its work of providing speedy disposal of cases, but the need of expanding its scope, which was stressed by Delhi High Court in the case Abdul Hassan versus Delhi Vidyut Board. In this case, the court stated that the award passed by Lok Adalat, judges are now deemed to be a decree of a civil court, and a court fee paid in such case is liable to be refunded in the manner provided under the Court Fee Act of 1870. These awards are final and binding on all the parties to the dispute, and no appeal lies to any court against these awards. It is thus very important that we should put these provisions in active use and try our best to hold as many Lok Adalats as possible and include therein different categories of cases like matrimonial disputes between husband and wife, bank loan matters between banker and customer, land acquisition disputes, matters relating to industrial disputes between employee and employer, landlord and tenants, controversies, any other controversy, and petty criminal cases. Besides this, the cases between government, state owned corporations can also be settled through Lok Adalats.